Good afternoon, everyone, and welcome to this session of our conference, which is dedicated to the situation in national jurisdictions. For those of you who were with us this morning, you know just how important it is to consider the specific situation at national level, because in EU legislation, so much is left to the national level. And this session is going to give us a chance to speak to 4 people who know the ins and outs of what's going on in their particular national contexts. Let me introduce our first speaker. We will have 4 speakers from 4 different countries. Our first speaker is Arnaud Schwartz, who is the president of France Nature Environnement, which is the largest environmental organization in France. It is a network of almost 3,500 associations, which gathers around 900,000 citizens. He is also a member of the EEB Law Working Group, the European Environmental Bureau Law Working Group, and he is a member of the European Economic and Social Committee. Arnaud, the floor is yours for 15 minutes.
Thanks, Adam. Thanks and hello and welcome to everyone. In 3 steps. First, I will tell you what we see happening in France. Then I will show you what is maybe missing, and in the end also give you some idea of solution we are promoting. Our members are on the ground struggling with a lot of issues and preventing nature loss or biodiversity loss, pollutions, and what we try to do is make law or applied in the way our environment is protected. Of course, whenever it's needed, we also are trying to make law work in the sense this when it happens, pollutions or losses are punished. But this is not our first, this should not be our first action. What this first, what we see, we should be here to prevent, but in fact we are here to ask for punishments. And why are we seeing that happening in France? Because we are lacking people on the ground watching if things are going well. We miss a political will that gives money for people and tools in order to explain the stakeholders what the law is and how it should be applied, and also people to control if it's well applied, as well as people if it isn't well applied to punish these stakeholders not respecting the rules. We also miss, in a way, strength in the punishment we can obtain with our action when we are going to court. In France, you have a kind of separation between activities or rules that make it difficult to condemn public authorities not respecting themselves the law. And of course, the fact is that with our centralized state, some kind of public authorities called préfets are very powerful and have to make choices considering several kind of opportunities and in first hand economical ones. This is why often environmental law isn't well applied, and this is why also we have many difficulties to explain the European Union that France isn't as green as it pretends to be. We are also not only having this kind of trouble because in France, when you go to court with local or public authorities, they are rather protected from being condemned. We also have issues with the fact that justice itself is lacking people and is moreover lacking specialized people, prosecutors, judges. And as our environmental laws are pretty much complex, these people, if they are not sensibilized, they cannot judge very well. And it happens very rarely that a punishment is very well pronounced. And so when you understand that you first on the ground don't have enough inspections, so you don't see a lot of problems, and then the few problems you see when they come to court, if you have judges or prosecutors that don't understand very well what it is about, you have not very few, but very rare cases with positive issues for us as environmentalists. What we also feel is missing in our country is a lack of strength given to citizens and mostly associations like ours, with a lot of backlash in the past years, a lot of tools we were used to have, tools that were not very good to participate, to access to information, to access to justice, but tools that are destroyed or watered down. The better regulation agenda has made a lot of harm in France and still does in the past weeks. Of course, I don't want to say that France is the worst country, because I know I have colleagues abroad, and it may be worse in some other places, but still you have to keep in mind France is not as green as it pretends to be. Another example I have to give is that in our system, it's very inefficient when you're facing a risk of imminent destruction of the environment, and you want to stop it. And you say, here we are, citizens, we are or associations willing to protect the environment. We tell you there's a problem with this project. They should stop now, not in 2 weeks or 1 month. You have to judge rapidly and tell us if it can go on or not. Because if you don't stop now, afterwards, there's nothing left on the ground to judge, because, for example, trees will be cut down or something like that, you know. So this case in France doesn't work. You cannot stop and have a judgment rapidly. So in the end, there's nothing left to protect. And I also have to add that with the all the levels we have in our justice organization, it's very complicated for us to ask questions that could be treated by the European Court of Justice. Our French system doesn't like that. It's trying to block all kind of question we would like to ask, so that Europe could give us an insight on how law should be applied in France. And the French justice system makes it very difficult for us to get the really essence of European law being applied on the ground. And so we have to gather a lot of proof, and we have to complain so that we are heard. But of course, when you try to complain, it's very difficult, because you have this work to do, gathering proofs and so on. And also, in the end, it's difficult for the European Court of Justice to attack a member state. They don't dare, or they don't like it. It's complicated for them as well. So we are pretty much flooded on the ground, and we have not only to count on justice, but also we have to rise in people's mind consciousness for environment, and the will of the citizens to choose governments, local or regional or national governments, that are much more keen on protecting the environment, because justice in itself isn't helpful enough. Of course, we also have some proposals to make. I will be very short because my time is already almost over. We first say we should stop with this better regulation agenda. Watering down rules is no way. We have issues to face in the coming years. Science tells us no time to lose anymore. So stop this better regulation agenda. Secondly, give means give tools, hire people, because we need human beings on the ground to explain what the law is, how it should be applied, and eventually to judge if it's not the case. And thirdly, we would like to see in our country an independent authority for the environmental protection that could say if one project or another is in line with the rules and not going on with this compromise situation where préfet, where these state representatives are always making confusions between economical pressure and environmental law. The fourth proposal we have is, as I already said before, to specialize our prosecutors, judges, and so on, police also. And I'm already done. We also have to get sanctions harder. We should create some new kind of sanction as well for all these activities that are threatening the environment, and get to conclude, we should also get a strengthening of the role of civil society organizations. Thanks for listening.
Sorry about that. I think I was knocked off for a second, but I did hear the end of Arnaud's discussion. Thank you so much, Arnaud, for giving us a sense of what the challenges are in France. And indeed, one theme picks up from this morning, which is the difficulty in particular of getting French judges to refer questions to the Court of Justice of the EU. Although not a problem unique to France, it seems to be one that's acute there. Our next speaker is Ana Barreira, who is a lawyer and is the director and founding member of the International Institute for Law and the Environment in Spain. IIDMA is the Spanish acronym. It is a non-for-profit environmental law and policy center. Ana participates in negotiations and has published extensively on international, EU, and national environmental law and policy. Ana, the floor is yours for 15 minutes.
Okay, thank you very much, and welcome everybody. I see now we are around 100 people connected. I see so many friends. It's a pity we cannot be in a room all together. So I say hello to everyone and good morning to some of those that are joining us today from Latin America. So I'm going to make an introduction or an overview on issues regarding access to justice in Spain. And I want to share a bit our experience because IIDMA, which is the International Institute for Law and the Environment, that I might say that we have recently celebrated our 24th anniversary. We have been a member of the project on access to justice project that today is the final conference. So please, Capuchin, could you show the PowerPoint presentation and the topics I'm going to cover today, because I don't have the time to explain everything about access to justice in Spain. I'm going to concentrate on the specific or the main important barriers that Aarhus Conventions tried to solve or to give a solution. And these are regarding standing, injunctive relief, the issue of time, the issue of the cost of a case, and also I want to speak about other essential elements on access to justice in environmental matters that is not, they are not themselves in Aarhus, but these are topics that have been discussed in the different conference meeting of the parties of these conventions. First, I want to say that the Aarhus Convention was ratified by Spain in December 2004, and it was published in our official journal in February 2005. Why I'm saying this? Because it's important, because under Spanish law, once a treaty is published in our official journal, it becomes internal law. And members of the public, interested parties, can consider this and allege the treaties before the Spanish administration and before Spanish courts. And under our law on the international conventions, a treaty that has been ratified and published in the official journal has primacy above all the laws we have in Spain, except the Spanish Constitution. So now I'm going to go through to the issue of standing. I would say that before Spain ratified Aarhus Convention, of course, we have difficulties regarding standing to sue. And there were cases, and there are cases before the Aarhus Convention of NGOs that tried to bring cases before Spanish courts, and they found barriers on these issues. Not always. There were different interpretations. But because of the Aarhus Convention ratification, Spain transposed, if we can say that about international law, we say that about directives, the law 27/2006 of 18 July on access to information, public participation, and access to justice in environmental matters. This law introduced a qualified actio popularis. I said qualified because it's not an open actio popularis, but it is in line with the requirements of the Aarhus Conventions. So this provision, which is it's combined Article 22 and 23 of this Aarhus law, grants standing to the following non-for-profit legal persons. These are, I would say, the requirements that non-for-profits legal persons have to comply with in order to have a standing to sue. So they have to have among their objectives introduced in their bylaws the protection of the environment in general or as one of its elements. In addition, they have to have been established 2 years before the starting of the litigation of the case before the court or before the administration, and they have been active to comply or to achieve the objectives that they have included in their bylaws. And finally, according to their bylaws, they have to develop their activities within the territorial scope affected by the administrative act or omission that is being challenged. So for this, in order to comply with this, it is required the legal registration. So to become a non-for-profit legal person, you need to be under Spanish law an association, then you are registered in the association's registries or in the foundation's registry if you are a foundation. I would say that thanks to the Aarhus law, there has been a very wide interpretation of standing. And I would like to share with you a case that I was the lawyer for. I was litigating on behalf of Oceana in Spain. There was a case of some discharge of ballast waters in a Spanish territorial sea by 2 vessels, and this was against the MARPOL Convention. And the Spanish Ministry of Public Works, where is the competence on marine transportation and ports, they open an infringement procedure against these two vessels, the owners of these two vessels. And Oceana wanted to be a party or a part on the infringement procedure. And of course, the first instance court did not recognize this quality of Oceana to be a concerned party, because under Spanish infringement procedural law, it has been always very limited, the concept of concerned party, and never was considered an NGO to be, but only those that the procedure was opened against. But the Supreme Court considered, because of Aarhus provisions, that the discharge of ballast waters is affecting marine biodiversity, according to my allegations, and they consider that NGOs can also have a standing in infringement procedures, which are administrative proceedings, because when we talk about access to justice, we are not only talking about access to justice in courts, but also access to justice before the administrations, before the different administrative bodies. So this is a standing. I can say there has been a lot of progress. Regarding injunctive relief, it has been really tough, particularly the issue of bonds that I'm going to concentrate on. For example, at the beginning in the previous years, in 2012, there was a case of a resort that was developed in a special protected area under the Birds Directive. And the Supreme Court of Extremadura declared that that project was null and it was against the provisions of the Birds Directive and the Habitats Directive. Then the NGO that challenged that decision of the authorities of Extremadura authorizing that development project, that resort development project, they wanted to stop the execution of the works because the Extremadura authority took the case they appealed the case before the Spanish Supreme Court. But the Supreme Court of Extremadura said, yes, that was that they hold, yes, we can stop the work, but you have to put a bond of 41 million euros. So that was impossible to comply with. So that was very tough. Also, in another case in 2014, in which there was a decision by the Madrid regional government to build new lanes in a road, which was in a Natura 2000 site, and the Supreme Court of Madrid annulled that decision to build, but the Madrid government appealed the judgment before the Spanish Supreme Court. So then this NGO, they requested again the provisional execution of that judgment, meaning to stop the construction, not to start the works. And the Supreme Court of Madrid fixed a bond for injunctive relief of around 5,100 euros. So in 2014. So again, that was very difficult for the NGO to have that money and to show it in court. But finally, recently, last year in 2019, there was a case regarding a low emission zone in Madrid. That was a very contentious case. And there was a change in the Madrid municipality, and the new Madrid municipality government decided to reverse the low emission zone. But a group of NGOs, they brought a case and they asked for injunctive relief just to avoid the reversal of the low emission zone before there was a ruling of the Madrid court. And the Madrid court allowed and granted the injunctive relief and allowed to keep the low emission zone operative while the case was pending without any bond. So I can say that we have good developments in this sense. I cannot say that it's a generalized practice, but the issue on injunctive relief is improving in Spain. Another of the aspects I want to cover, it's about the cost. And IIDMA had recently a court case regarding, we appealed the Spanish Transitional National Plan for large combustion plants in 2017, because we thought that that plan required to be subjected to a strategic environmental assessment. The case was dismissed, and then the court just condemned us to pay the cost. That was the total amount with VAT was the 11,260 euros. In October 2018, the court undertook the cost assessment or appraisal. And finally, there were decrees of the Spanish Supreme Court, that was the competent court where we filed this case, approving the cost. And then we challenged that decision. We challenged that decision because we were granted legal aid. And the Spanish National or Central Commission on Legal Aid approved IIDMA or grant IIDMA the legal aid because direct application of the Article 23(2) of Aarhus Law. And this means that we didn't have from the very beginning to prove that, or to show evidence that we were not able to pay the case, that we didn't have resources enough to cover this litigation. According to the Spanish legal aid law, sometimes when you, or most of the times when you ask for legal aid, you have to show or to prove that you don't have enough resources to litigate. But there is an understanding by the courts in some cases that if you apply directly the Aarhus Law provisions, you don't need to prove that you don't have enough resources to litigate. So the decree of January 2019 said, okay, you don't have to pay now, but if you have enough resources in the next 3 years' time, you will have to pay in application of Article 36 of the law on legal aid. So when we challenged that, the Spanish Supreme Court considered that because we were granted legal aid according to a direct application of the Aarhus Law, Article 23(2), we don't have to pay the judicial cost regardless of the means we will have in the future. So these have very important implications for the cost for NGOs bringing cases to courts, because applying directly this article of that Aarhus Law directly exonerates NGOs to pay the cost. But what is necessary first is to initiate the procedure to be granted legal aid, which is just an administrative procedure, and you can get access to legal aid. So I would say that we also have advanced quite a lot. And in fact, Spain had a case some years ago before the Aarhus Convention Compliance Committee on this matter. There was a decision, which is 6/8J from the meeting of the parties requesting Spain to provide free legal aid to NGOs. So this, the Spanish Supreme Court, in a sense, has respected the decision of the compliance committee, the Aarhus Compliance Committee, but now they still will need to introduce changes in our legal framework. Finally, there is another issue which is really very important, because as I've been explaining, the situation in Spain regarding access to justice is quite good, but there is something which is critical, because when we are, because if we take a case before a court of law, it means many times that the projects are starting, that the projects, they are not complying with the laws, they are against the law, and we don't want that. We don't want that. We as a lawyer, we should be happy not to take cases to court, because if we go to a court, it will take a lot of time and the damage might be caused. So in Spain, I have taken this from the EU Justice Scoreboard. And as you can see here, okay, there are all the member states, there are data for Spain. It's the time needed to resolve administrative cases in first instance courts. I would say that here is very, it's an average, it's very positive, but our experience shows that a case in first instance, it takes around 2 years, but normally we have to appeal. So if this is too long, then the damage is going to be caused because it's difficult to get many times, as I explained, injunctive relief. So this is critical. And that's why the other essential elements for access to justice in Spain, and I think that will be applicable to all jurisdictions, is what are the resources provided to administrations and to the judiciary system. We need to improve that. I mean, without resources, the cases takes very long, and then the defense of the environment is really under challenge. So therefore, a critical element for access to justice is not only standing injunctive relief, the time and the resources, because it's linked to the resources, it's critical. And of course, even if we solve these problems, we need trained judges, because our experience shows that the fact that we don't have trained judges, or we don't have specialized chambers or even specialized courts, you get many times rulings that are really surprising. So I think this is also critical as another element on access to justice in Spain. But as a conclusion, I don't know if I'm on time because I haven't been checking the time. I would say that, yes, access to justice is really very important, but I think that we have to avoid going to courts unless all these barriers are completely broken. Particularly for us in Spain, the training of judges is fundamental, is critical, together with having resources enough for courts to take decisions on time. So I'm open to any question, and I hope that you find this experience in Spain or this overview useful for your work. Thank you very much.
Thank you so much, Anna, and particularly for those very specific case examples. And for a point that I think now certainly connects France and Spain, which is this issue of a lack of specialized judges in particular. Let's move on to our third speaker now. Kadi-Kaisa Kaljuveer is a public interest lawyer and co-manages the Estonian Environmental Law Center, EELC. She is familiar with national and international access to justice legal matters and has been advising the local community, individual citizens, civic organizations, and administrative body officials in Estonia. Kadi-Kaisa, the floor is yours for 15 minutes.
Okay, hello everybody. First of all, I have to apologize. I have a little puppy at home, and if he whines a bit, then don't worry, everything is fine. He's just wanting attention, but I hope it won't bother us much. And thank you for the introduction. And today, the presentation I'm going to give is put together mainly based on our work in EELC that we have done, and also the sessions that we had with the local legal professions that we had really good conversations with. And if I start by talking about the issues in Estonia, I try to generalize them, and I hope I can give you as much as possible with the time given to me. And if we talk about access to justice in Estonia, and the first thing that came up when we talked with experts and legal legal lawyers, and was the issue that why are we going to them? Because they felt like the main issue in Estonia that we have is that the people and the NGOs need to know more about access to justice on a general basis, how to go to court, what are their rights. And I think I can agree with that. And I think there is a lot more work to be done on that matter. And I hope that that it will be done further on with maybe new projects or just the work that the EELC and other NGOs are doing in Estonia. And the second thing that in a general view came up was about the judges, like Anna pointed out, is the issue in Spain as well, is that the judges aren't specialized in Estonia. They come up, they have a lot of different issues that they have to work with, and specialization in a small country like Estonia isn't always an option. And the judge getting the case might not always be aware of the specific issues in regards to environmental issues. But if we go more into details, I want to talk about today briefly about the standing conditions in Estonia. I want to talk about injunctive relief, burden of proof, and proceeding time in general, and also a bit about costs. And when we start with standing conditions in Estonia, I can say that the main thing that when you are a private person, you have to think about, and you want to challenge something in regards to environment. I'm so sorry. Can you hear me? Okay. Can you? Yeah. Okay. Great. Because he's whining a lot. And when we talk about private persons, and if they have an issue with environmental questions and they want to go to court, I can't say that there are many restrictions. If there is, if they are in regards to your own matters, and a bit of, and another thing that private persons in Estonia have is that when they want to talk about spatial planning and more wider representation going to court, they also have in Estonia an option to go against, for example, detailed plans into court and tell to the court that they are talking about they are talking on behalf of a wider community there. They have also that right here as well. But it's restricted to only spatial plannings, detailed plans, for example. And when we talk about the environmental NGOs, then we can say that the definition, what is an environmental NGO, is quite. If I don't know if the easy it's a quite wide translation what an NGO, environmental NGO in Estonia is. And that has brought up some questions in recent times, that if an environmental NGO should always be an environmental NGO, because we see in practice that I can't say that it's always the case, but there are cases where it's under question whether or not an NGO is actually working on behalf of environment or their own subjective issues or beliefs that they should get the right and the representation for themselves. So there are some questions about that, but I can't say that it's a really wide one. But and the NGOs in Estonia usually are working for the environment on a broader spectacle, then, if I can say. And when we talk about on what they can or what are the issues that they can go to the court with, I can say that the recent cases show that the courts are putting more emphasis on the fact that they should go to the court only on the matters of the environment. So if they are an environmental NGO, when they go to court, all of their arguments should be around the environmental matters. So that's the one thing I can bring out from the standing conditions. And when we move on to injunctive relief, it's a bit of an issue in Estonia, because when we go to the court, for example, on detailed plans, and we want to get the injunctive relief, it's usually not granted. And the fact is that the courts are really restrict on the fact that if the, for example, a detailed plan doesn't conclude in direct action, for example, building something, and you need before that the building permit as well, then the injunctive relief isn't granted for the person who is going to the court. So that brings up kind of like a double situation, where we have a detailed plan that is going, that is still, what's the word? It's still, well, you can move on with the things, and for example, you can give out the building permit, and then you have to go to the court for the building permit as well, putting more emphasis on the environmental NGO, for example, to work parallelly on two cases. So there is some double burden for the people going to the court against like a general idea. We know that it's going to happen, but when we're still at detailed planning process, and the permit has, the spatial plan has been given out, and it's still legal, you can't actually get the injunctive relief for that. You have to wait for the building permit to happen, and then hopefully you will get it. And when we talk about burden of proof, I think it was important to bring that out as well, because it was the first thing that came out when we sat down with the judges, that we have these SCAs and environmental assessments that are given out when they are giving out permits or spatial plans or and so on, that they are they are really detailed. They have their own procedure going on, and it's quite hard for an NGO to go against when going to court with their own assessment that would be as exact or as followed by the process as the assessment that was given out by the building permit wanter. And that when we asked from the judges that how do you assess which one of the assessments is more trustworthy or more more trustworthy, then they kind of like said that well, it depends, and it's not written in stone, but we can see that the assessments that are following the procedure and are given to the decision maker might be more trustworthy for the judges as well, but they didn't like give us the assessment that they always go with, the assessment that was given out by the building permit wanter. So but it is an issue, because as an NGO you don't always have the resources to go through with an assessment that is as on the same level as the assessment that was given out by the building permit wanter. And with the timings, as I saw from previous Anna's chart, that in Estonia it's quite fast going. I can't say that it's always true, because it depends really on the case, and we can see that for example, the cases where the injunctive relief isn't given out, it's quite of an issue that the timeliness it takes still a long time, and the proceedings can go to 2 years as well in Estonia, and it's only on the first instance. And when we go through all the 3 instances in Estonia, the time can be still quite long. And as we can see with the COVID happening, even the getting in touch with the courts has become a bit more restricted. We don't get as much attention from them as we did before. So I can say that maybe not the timeliness. I can't say already that the timeliness is affected by COVID, but we can see that the courts aren't as responsive as they used to be. And for the last thing, I wanted to talk about the costs. And the main thing that I can bring out in regards costs is the fact that, yes, when going to court, it's not that expensive in Estonia. But the first question that the people or the NGOs that come to us is what happens when I lose, and not on the case that when we go against administrative bodies, but when there is always a concluding fact that a third person, the one who is going to the permit or spatial plan, is involved in the case and is involved in the court proceedings. That when you lose, you have to pay the costs of their legal expenses as well. Well, of course, we can ask for the reduction of the costs, and it's usually given out to the NGOs. I can't say that it isn't, but there is still a fact that it's the fact that will put many people or NGOs into the question mark whether or not should I even go to the court. And we can see that it may become an issue in environmental matters in Estonia. So I think that was my brief overview of the situation in Estonia. I think I'm still in time, and I want to thank you for the opportunity, and I hope things became clearer from Estonian side as well.
Thank you so much, Kadi-Kaisa. That was very interesting to hear from your experience, particularly in a jurisdiction that many of us will not know as well, and also the experience from a smaller jurisdiction, which tends to be different. And now, last but certainly not least, we have Kathleen Pauleweit, who works at the UFU, which is the Independent Institute for Environmental Issues in Germany. Sorry, I cheated by giving English translation. Kathleen is at the Department of Environmental Law and Participation at UFU. She is also a PhD candidate at the University of Kassel. She is a former intern at the Secretariat of the Aarhus Convention. She holds a master's degree in environmental law and a bachelor's degree in comparative and European law. Kathleen, the floor is yours for 15 minutes.
Thank you very much for the introduction, and thank you also very much for the excellent speakers of the first and the second session for today. I prepared some slides, and thank you very much for sharing. So I'm the last one, but obviously not the least person to give a small introduction to the legal system of the European Union country, Germany. I hope you still have stamina for this fourth presentation. And I would like to give you today a small outline of the German state law, just very briefly, and then touch upon different topics for today. I want to put a focus also on standing provision in Germany. I would like to talk about the strict recognition criteria in Germany, and also about the scope of judicial review in Germany. And last but not least, I would like to talk about new legislative developments in Germany when it comes to environmental information. And afterwards, I hope we still have some time for discussion. So first things first, to just get you on board. Obviously, most of you are familiar with Germany, which is a federal state and consists of a federal central government, and it has 16 federal states, which are called Bundesländer. So the administrative branch of the German court system has the general jurisdiction for all types of decisions, omissions, and factual deeds of the executive branch of government relating to the environment. In Germany, we don't really have independent bodies like ombudswomen or men or specialized tribunals for appeal at this point in time. And starting with this, I would like to, go into the implementation of the Aarhus Convention for this second and third pillar. So what are the basic issue we face in Germany? So in Germany, we have quite narrow standing provisions. I'm not sure if you're familiar with the Code of Administrative Court Procedure in Germany, and the general rule is that there needs to be an impairment of a right for individuals. So we call this doctrine the theory of the protective norm. So every individual needs to have standing. There needs to be a legal provision of a statutory law, and this must at least also serve the purpose to hold an individual interest of the plaintiff. So, and the courts tend to be quite restrictive of this act, and basically only property owner have the chance to have full legal review of permits or other types of authorizations. So, but this is all what I want to say about individual access to justice in Germany, because I would like to focus today my presentation about the exceptional rule for environmental NGOs in Germany. So recognized environmental NGOs, they have a special status in the German legal system. They don't need to be an impairment of a right, which is stated in Section 2 of the Environmental Appeals Act. So, but before I go in more detail to this exceptional rule, I would first like to point out some issues about the strict recognition criteria for environmental NGOs in Germany. So the problem we have or not the problem, I should rather say that there is an exceptional historical development in Germany when it comes to the recognition procedure for environmental NGOs. In Germany, you can be recognized as a nature conservation association, which is called Naturschutzvereinigung in legal terms or in German terms, and you can be registered as an environmental association, an Umweltvereinigung, at the federal or the Landeslevel. So there are two coexisting registration procedures, and both recognitions are causing different legal rights, litigation rights for the association. The problem we have for all of, like for the Nature Conservation Association, also the Environmental Association, is they all, in order to be recognized, they all have to fulfill 5 recognition criteria. And they are even stricter in Germany than, as we heard today, as in Spain or in Estonia. So if you want to be registered in Germany, you need to have a basic democratic structure, and you need to be established for more than at least of 3 years, and you have to show some activities within this year. And then we have some other criteria, but Those two I've just mentioned, those are the most controversial one. And those controversial recognition criteria lead to the fact that very popular or well-renowned and famous NGOs like Greenpeace or the WWF Germany, they can't be recognized, so they don't have legal standing whatsoever. And this lead to a communication filed by the WWF Germany and a communication to the Aarhus Committee in Geneva, and the case is still pending, and we are waiting for the findings and recommendations of the Aarhus Committee. I was actually hoping to ask Mrs. Ryle today about the upcoming developments around this communication. So, but in my legal opinion, what I think is that when we finally get the findings in the case C-137, that we might see another amendment of the most important legal instrument we have for litigation rights for environmental NGOs, which is the Environmental Appeals Act, and I want to briefly discuss or give some general comments on this legal piece, because it's quite interesting. So what is interesting about this legal instrument, the Environmental Appeals Act, or the Umweltrechtsbehelfsgesetz in German? So Germany adopted this law, which we highly welcomed in 2006. You see it here on the timeline. It was adopted in 2006 only, and within the last 14 years, we've seen seven amendments. On the timeline, you only see 6. I added the last one, which took place in 2018. So as you might imagine, or I want to give you an impression that all those amendments, all this dynamic in this area of law also leads to legal uncertainty. And not only that, it also shows us the reluctance of the German legislator to comprehensively or completely or fully implement the Aarhus Convention and the EU law. And if you really have a look on the law, it's quite complex. It's very technical. It's one of the most technically difficult procedural laws we have in Germany, and you know, we Germans are not really famous for talking around the bushes. And one of our German renowned professors, he even said, this law is the model example of bad German legislation. So this law is not sexy, and this is why I think also some judges in Germany face some difficulties to apply it. So after those general comments on the Environmental Appeals Act, I want to deep dive into the narrow scope for judicial review in Germany. So what the problem we face with Section 1 of the Umweltrechtsbehelfsgesetz is that it entails a concluding or final list of different acts and omissions. And there is another pending, already admissible communication in front of the Aarhus Committee around the issue that Germany is still not in compliance with the Aarhus Convention and the applicable EU law, because this final list probably doesn't entail all relevant acts and omissions. I could later give you some more example and go in more detail to this. But what I also want to say, and I also want to point out, is that we in Germany not only have a very tight list of acts and omissions which are entailed in this Environmental Appeals Act, but we also have a huge discussion about preclusion, material, formal preclusion, general preclusion, and I could hold a long speech around this topic only, but what I wanted to say is that we see this development, even though now we don't have the material preclusion anymore in the Environmental Appeals Act. It was done by the 7th Amendment to the Environmental Appeals Act, that we, like the legislator in Germany, still finds its way to give other restrictions or other access to justice hurdles for environmental NGOs. So now we don't have the material preclusion provision anymore, but now we have the legislator added Section 5, which is called the provision on abusive or dishonest conduct in the appeal procedure. And it is quite unclear, not only among environmental NGO members, but also among scholars, what is the content of this norm, and it's not really clear what it is supposed to mean. But the fear is that it might be a sneaky way to bring back the material preclusion, so that every argument which wasn't dealt with in the administrative procedure can't be brought in again in the judicial process. So we environmental NGOs obviously have limited resources, and we cannot always attend the administrative procedure and bring up our arguments and claims, and we are afraid that we are seen by the legislator as a quasi-assistant of the administration. So obviously in line with the Aarhus Convention and the applicable European Union law, we need to have our access to justice rights apart from administrative procedures. And also another point which is interesting, and we've seen by the legislators, that it not only introduced this abusive and dishonest conduct provision, but it also introduced Section 6 into the Environmental Appeals Act, which brought some other stricter requirements for environmental NGOs in the administrative in the judicial procedures. And one strict requirement we don't have in the general administrative law in Germany is that the NGOs or the individual need to give its statement for its claim within 10 weeks. We don't normally have a strict deadline like that. So we see basically a double standard when it comes to access to justice for environmental NGOs. So what is the result of all of this? I mean, I painted a quite frustrating picture so far. And in fact, we've seen, because my institute, we're also doing some legal empirical studies on access to justice for environmental NGOs. And what we found is that only a few of those around 300 recognized NGOs in Germany used the access to justice rights in the past. And probably those NGOs which were active, you don't even know, because they're more renowned on the national level, which is the BUND, the NABU, or the UH, which is the Deutsche Umwelthilfe. But as I said already, because of our very strict recognition criteria, Greenpeace and the WWF, they can't be recognized, they don't have legal standing. Foundations in general are not, can't be registered either. So they haven't been active so far. And in the period, as you see on the slide, in the period from 2007 to 2012, we've seen only 149 lawsuits by environmental NGOs. And in the period from 2013 and 16, we've seen 150 lawsuits by environmental NGOs. But anyway, we are still cautiously optimistic, because we've seen, after the 7th Amendment of the Environmental Appeals Act, we've seen broader access to justice and more active NGOs. And now I would also like to briefly talk about access to justice rights when it comes to denied environmental information requests, because there is a new development in Germany I would like to share with you. So, so far we in Germany, we've all disputes around denied environmental information requests have been heard by administrative courts. But in September, the BMU, the Federal German Ministry for the Environment, came up with a new draft, Section 7a for the Environmental Information Act, and they want to introduce a new alternative review procedure, and not before the administrative court, but before the Federal Commissioner for Data Protection and Freedom of Information. And we are not really familiar with those kind of alternative review procedures in Germany. Maybe it's comparable with the European Ombudsman, but I definitely would like to have a brief discussion later on if we still have some time left. I would like to have some discussions around other experiences with those kind of ombuds or dispute settlement procedures, and I would be interested about legal pitfalls and everything which is interesting to know for our future work. Oh, yeah, it's perfect. Next slide, it's fine. So to sum up my very short and brief ride through the German access to justice rights, I would say that the implementation of the Aarhus Convention is in Germany is still under pressure, and the implementation feels like a cha-cha-cha dance or a disco fox, because with every step, with every new amendment, for example, of the Environmental Appeals Act or the Environmental Information Act, we have this impression that the legislator is more willing to get engaged into a participatory democracy. But on the other hand, we also see those setbacks and backlashes. We see political discussions about reintroducing the material preclusion. And so I think German NGOs and probably also EU NGOs, we still need to stay alert and be very cautious about political developments, and we have to remind and take our governments accountable for not helpful legal developments. So thank you very much for your time, and here are my contacts. If you want to know more about the detailed country report my dear colleagues prepared, or the legal empirical studies we do at the Independent Institute, please contact me. I'm very open to respond to all of your questions, and thank you very much for your attention and time, and I hope we will have some fruitful discussions now.
Thank you so much, Kathleen, and thank you to all of the speakers. We have only about 15 minutes, so what I would suggest that we do is go speaker by speaker, and what I'll try to do is raise some of the common issues. And as we go to each speaker, I'll also try to raise some of the specific issues. It seems to me that there are a few common issues that came up. One, which is interesting, is about the acceptance of foreign NGOs in your domestic legal systems. In theory, I suppose, as a matter of EU law, an entity established in one member state ought to be able to appear in the courts of another member state as if it were from that second member state. But in practice, how does this work? And there were some questions about systemic misapplication of EU law and going to the European Commission with complaints about that. So Arnaud, I may turn to you first, and maybe if you want to address those questions, and also something that came up, which is a question about whether there is a cost structure that you've established in France for assessing damages.
I may not be able to answer this cost question, but the one about complaints, indeed, I already talked about it. Our big issue is being heard by the union, because we have to gather a lot of proof, and not only we as French citizens have to do this, but we should also have other friends abroad doing the same on the same topic. For example, access to information. And then only the Commission or other European bodies could say, okay, let's see what's happening. We have several member states having the same kind of issues with not really implementing, for example, this Irish Convention pillar, access to information, and let's deal with them. But it's really a long way to achieve something, and we are working on it. For example, on this topic, access to information.
Okay, yeah.
Thank you. Please, Anna, feel free to address those questions.
Yes, on the case of access to justice by foreign NGOs, okay. It depends, because if you read the standing, I mean, how it is recognized, the qualified actio popularis in Spain, there is this requirement that the NGO is active in the area or in the territory where the case that brings the litigation is taking place. So I don't know. It will depend also, as you know, law, it's open to interpretation. So I cannot give you a final answer. So it will be a question of seeing if there is a case, what is the understanding of the Spanish courts. But I see this is a burden to show. On the question on standing, for example, on access to environmental information is not a problem in Spain, even for foreign NGOs, because the Aarhus laws, when they defined who is the applicant for environmental information, already recognize it as interested party or as concerned party. So therefore, there won't be any problem. Of course, our experience on access to environmental information in Spain, as it happens in the case of Germany, we have 17 autonomous communities or regions. And our experience shows that in some autonomous communities, they are really very open. There is no problem on access to environmental information. And in some others, there are problems on access to environmental information. So there is not a common practice. And on the final question on going to the European Commission to bring, what I understood, the question is if it's good to go to the European Commission to bring complaints. That was the question. Did I understand correctly? Okay, in our experience, again, I must say, we have filed in several occasions complaints to the European Commission, and the European Commission takes years and years. So sometimes it's even worse than the national courts, or at least Spanish courts. I have experience some years ago on a case about the use of mercury cells to produce chlorine before the reform by the Industrial Emissions Directive, when it was enforced, the IPPC directive. And it took the Commission 5 years to take a decision, and it was because I brought the case before the European Ombudsman. And the same, we are expecting a decision of a complaint we filed on Spain about how Spain transposed the best available techniques provisions of the Industrial Emissions Directive, and we are still waiting for an answer. So therefore, if we want to defend the environment, if it takes so long, I don't think that the European Commission a tool of complaints, it's as it was before. Before, like 15 years ago, it was a very effective tool. Nowadays, it has lost effectiveness, and therefore, I won't advise it as a good tool for the protection of the environment. Thank you.
Thank you, Anna. That's a bracing note, but an important point as we see how things evolve. Kadi-Kaisa, if you have any thoughts on these issues, and also there was a separate question for you about whether you're aware of any environmental NGOs bringing a challenge about approving a water management plan in Estonia, very specific.
Yes. Well, in regards foreign NGOs in Estonian court, I can't come up with any that has gone to the court. I might be wrong. Maybe there is some, but as Anna said before, like I think that Estonian legislation is also up for interpretation, and I wouldn't rule it out that an NGO that would qualify as an environmental NGO in Estonia could go to the court and challenge something, but I have no knowledge of any pending or previous cases that where an NGO has gone to the court, like a foreign NGO. In regards access to information, I think that the main question that comes up in regards to that is what is an environmental information that we are asking for, because we see a lot in practice that the administrative bodies they tend to put everything under restriction without actually knowing whether or not we are talking about environmental issues in the acts or in some conversations or documents. So I think there is a lot work that needs to be done on actually knowing what the environmental information is and gaining and giving it out to the public as well, before they decide whether or not should it be restricted or not. And the third question was about going to the European Commission. I don't see that as an effective tool as well in Estonia. I know that there is one case that we there was a going to the European Commission in regards logging in Natura areas in Estonia. I don't know the current state of it at the moment, but there was a complaint given out to the European Commission in regards to that. And the last one was about water management plans and challenging them. I don't know that there are any current cases. I think that there is a possibility to go against that as long as there is an administrative act. You can challenge it in Estonian courts. But when we talk about plans and strategy documents in general, I don't see that it's a really wide practice that people go against those. The main issue probably might be that the fact that you need to prove that the measures given out there or the plans that they have made, that they will not be reached for sure. So, yeah.
Thank you for that. And I wonder, Kathleen, if you've got any thoughts on these general issues and also some of the specific issues that were directed to you about Germany, which I think you were starting to respond to in the chat as well, but about EU standing being an outcome of the Trienal case, which I have to admit I'm not aware of, or about the infringement of property rights. Kathleen, I'm not sure if you hear me or if it's a problem on my side. But while we wait to get Kathleen reconnected, and Kathleen, feel free to jump in as soon as you are back. We have some other questions that have come up that I think are quite interesting. One from our ClientEarth colleague Anais about whether specialist environmental courts would help. This is something that came up quite a bit about judges. I wonder if any of you have thoughts about this. And also and it's related to a question that came up about judicial training and the independence of the judiciary and how we square that circle of trying to make sure that judges know about the issues that we care about without making it look like we are trying to bias them.
Yeah, I can answer.
Please do, Anna, thank you. Yeah.
Yes, my personal opinion about having specialized courts, I think it will help because the fact that cases goes to the administrative courts, of course, under Spanish law, there is also environmental crime, and we have special jurisdictions for crimes. But the administrative courts, they are with bottlenecks, always fighting bottlenecks. So that will allow to improve is it working now? Yeah, okay, because it seems that something was wrong. Just to have the timely requirement of the Aarhus Convention, what that could be really solved. But also, if we have a special chambers or courts, that means that the judges will be specialized, and then we can expect rulings of a better quality, with better motivation or explanations of the rulings, and yes, in all senses, I think it will be an improvement.
Thank you for that, Anna. I don't know, Kadi-Kaisa or Arnaud, if you have any thoughts on I think we probably all agree that having specialist environmental judges would be an improvement. Is it a practical possibility?
Well, I think that the main problem that might come up in Estonia is the fact that we are a really small country, and the judges like specializing in one or two maybe specific areas would be like a big financial burden for the court system, like giving up because as a small country we are limited with the law, like judges, and having a bigger quorum of judges would mean a really big change in Estonian system. Like, I think that would be the first thing that will come up to my mind and to others' mind, that where do we get the judges that would be specialized in different areas, and how to finance that as well.
In France, we are moving towards this direction. By the end of the year, there will be discussion in the parliament about this, or by the beginning of next year. And we are very much pushing for it, and also having talks with our governments, because it would really help. And I have to leave. I only have 5% left battery on my computer. Sorry. Thanks for organizing this. Thanks a lot.
Thank you, Arnaud, and thanks everyone, because it's a challenging day technically, and of course always challenging with these various online events. Maybe perhaps just one last thought from Anna and or from Kadi-Kaisa. One of the issues that's come up on the screen is whether there's a difference between dealing with systemic and non-systemic cases. I think this would be about how the Commission handles things. There was also a question that came up about potential abuse of standing. This idea that, for example, people might found an environmental NGO merely for one purpose. I think Anna mentioned that there's a 2-year waiting period in Spain. So that would be one way that the authorities make sure that people cannot just start an NGO in order to deal with one specific issue, although I would ask why not, but then I work in the NGO sector, so I would say that. But I wonder if you have thoughts, perhaps Anna first, on either of those issues or anything else that you'd like to tell us about from your perspective.
Could you, I didn't understand very well the first question on systemic issues.
I'm not sure I totally understood it either. I think the question was whether I think it was for the European Commission, about whether the Commission should only deal with systemic cases as opposed to non-systemic cases. And then there was that was a question about what kind of whether we need a bigger watchdog, so I said a bigger watchdog than the European Commission, or perhaps maybe a more specialized watchdog than the European Commission.
Okay. I really don't understand well the question, because if you talk about systemic issues, I mean, if we take the Earth as a system, there are many things that are related, and everything is connected. There are many interactions, and therefore, I don't know if sometimes even there is an environmental issue that is not dealt by the environmental authority itself, but it's dealt with by another authority. But I really don't understand well the question, so I'm not in a position to answer that question. But the second question on the NGOs abuse, I think that our position at IIDMA is that we only bring cases when we have good arguments, when we have a third-time conviction and understanding that we have a strong legal arguments. Why? Because, as I said before, going to a court for me as a lawyer, I think is already a failure when you want to defend the environment. So when we go to a court, we want to win a case. We don't want, and then just with weak arguments, it's really, it's even an abuse of our democracy, because the courts, as I said, in our country is always under bottlenecks. So even I get angry with the authorities, they don't provide access to information, because I don't want to go to a court to get information which is already a right and is well written, because there are other aspects that might be subject to legal interpretation and you must go to a court. But environmental information, it's really, in many cases, ridiculous. So therefore, to avoid this potential risk of having people believing that environmental NGOs are abusing of the rule of law and going to courts, I advise to have strong arguments. Even in Spain, sometimes we have the losing party principle for imposing cost. But if the case have serious doubts, then you won't be imposed the cost. And if you argue strongly with good arguments, you normally are not imposed the cost, because the judge understands that there were uncertainties and there was a need for legal interpretation. So that is my response. Thank you.
Yeah, I 100% agree with Anna, because it really comes down to the arguments. Like we at EELC as also, like, we look at the arguments, and if we see a case that is worth going to the court with, we advise the NGOs to go to the court. And if we don't really see a good arguments or good case and a possible manipulation of the court system, or like just going to the court for the sake of going to the court, we don't advise that we don't give legal representations to the NGOs or private persons in EELC as well. So, yeah.
Thank you both for that. Thank you to all of the speakers for this very interesting session. I think they've given us really a view from the ground of what it's like in your countries to be litigating these issues and the challenges that we face, even though we're dealing with a common set of EU law principles in theory. In practice, it works quite differently, depending upon which jurisdiction you're in. And I think that we've raised some very important and interesting questions about how we raise attention to our issues, how we challenge them in courts. And perhaps the thing that sticks with me the most is how we manage to deal with a situation when we don't have the specialized judicial actors that we need to get our points across. Thank you also to the people in the background who have been typing answers to some of the other questions, including my colleagues at ClientEarth. And most importantly, thank you to all of you who have joined us for this session. We will meet again tomorrow to keep the conversation going, so please join us then. In the meantime, I wish you a good afternoon and evening, and thank you for being part of this event with us.
Okay. Thank you very much for the opportunity to share the Spanish experience.
Yes, thank you from my part from Estonia here as well.
Hi. Bye-bye.
Bye.
Bye.